with me today and myself. The first two, Professor Linda Mullinex and Professor Rhonda Wasserman, will discuss the US law. Professor Stadler will discuss the implication in Europe, and I will end with some aspects of Israeli law. So our first speaker would be Professor Linda Mullinex of the University of Texas School of Law. Professor Mullinex teaches civil procedure, mass tort, and class action litigation, and has authored several books and articles, including books on mass tort litigation and state class action practice and procedure. Professor Mullinex.
Okay, can you all hear me in the back there? Anybody? Is anybody awake back there? Okay, so I don't have a set of PowerPoints, which means that for the next 20 minutes, you're going to have to look at me. So I was asked, by the way, before I begin, I do want to thank Rabia Flavian and the university for inviting me to come participate in this very, very interesting conference. And also, I've never been to Israel, so I was very, very pleased to be invited and to be able to come here for a first trip. I was asked if I would do a presentation on the most exciting topics for law students everywhere, which is res judicata, enforcement of judgments, and jurisdiction. And so that's what I'm going to be talking about. And in thinking about this in the American context, it actually is a very interesting subject. And I've entitled my presentation, or my talk, it's called The End of the American Shangri-La, the Closing of the American Courts to Transnational Collective Actions. And what I'm going to be doing is very briefly talking to you about the scenario in American courts prior to 2010. But since 2010, in the last 4 or 5 years, we've had a set of very, very important landmark decisions from our Supreme Court that have limited the possibility of doing transnational class actions in American courts. And that has implications, interestingly enough, for what's going on in other jurisdictions around the world. And again, I will talk somewhat about that. So prior to 2010, in American courts, and chiefly I'm going to be talking, obviously, about American federal courts, some author or commentator in writing about the American class action litigation scene said that it was a Shangri-La for transnational suits, meaning class actions that brought with them numbers of foreign plaintiffs, meaning claimants from other countries other than the United States. And the reason why federal courts in the United States were being viewed as a Shangri-La was anchored basically in well-known differences between the American legal system and particularly civil law systems around the world. And there were a number of advantages to bringing litigation in the United States. Again, it's a very well-known list for people who study comparative law. In the United States, we frequently have novel or expansive substantive legal claims that don't exist elsewhere. We also have various doctrines which are favorable to the plaintiff's side of the docket. For example, in the securities field, you can pursue class actions, and there's something called the fraud on the market presumption, which allows these cases to go forward. It's a presumption of reliance. And again, it's a very, very favorable presumption that makes it easier to pursue these cases. We have contingency fee financing. We have entrepreneurial lawyering. We have attorney advertising in the United States, which is part of entrepreneurial lawyering. We have punitive damages that are available in many cases, which are not available elsewhere in many jurisdictions in the world. We have right to trial by jury, which is a sacrosanct right in the United States. And then we have the American rule on attorney's fees, so we don't have a loser pay rule. In addition to these differences, we have a number of procedural differences that made American federal courts very hospitable places for litigants from all over the world. And so, as many of you may know, we have liberal discovery regime, which allows the parties to the dispute to conduct discovery into all sorts of underlying factual matters relating to litigation, very expansive jurisdictional principles. We have liberal joinder rules, and finally, we have the class action rule. So for all of these reasons, American courts, again, were viewed as kind of something of a paradise. I had a former colleague of mine, Russell Weintraub, a great conflicts of law scholar, who once said he thought it would almost be legal malpractice for attorneys around the world not to sue in American courts. So that was the situation prior to 2010. And after 2010, we've almost had a reversal of this very open forum attitude in the United States. And what I'd like to suggest to you is it represents a convergence of three different jurisprudential strands. The first has been a very narrow construction under Rule 23 with regard to the res judicata enforcement of judgments. All right, so that's the first trend, and that's the first one I'm going to talk to you about. And then the second was a series of decisions from our Supreme Court, which basically imposed fairly severe limitations on the extraterritorial reach of subject matter jurisdiction in securities litigation and in human rights cases. And then right after that, the Supreme Court issued, again, a very important decision, which again limited the extraterritorial reach of American courts with regard to the ability of the courts to assert personal jurisdiction over non-resident defendants. And so when you take these three trends, things have become pretty grim for transnational litigation in the United States. In addition to these three jurisprudential strands that I'm going to talk to you about, there are other considerations that basically amount to limiting principles on transnational cases in the United States. First of all, and this has been mentioned over and over again today, and it's really very important, but the ability to pursue this type of litigation has been constrained by our opt-out principle. And we'll see in a minute how that works out. The opt-out principle applies in our B3 class actions, which are our compensatory damage class actions. And as you know, this opt-out principle has been repudiated or rejected in many civil law countries, although there are a few places now that are adopting the opt-out principle. At any rate, the existence of our opt-out principle in the B3 damage class action basically has been the primary driver behind impeding the possibility of res judicata application of American class action judgments. So what's the impact? What's the impact of this kind of closing of American courts to these transnational class actions? First of all, it's become very, very hard to pursue these cases in the United States. And as I will explain, it's not absolute, okay? It's not absolutely impossible, but it's become very, very difficult. And the other implication of what's going on is that with this kind of closing of American courts to these transnational cases, it's shifting the possibility of pursuing transnational litigation to other countries. For example, somebody wrote an article about Canada and said Canada is the new Shangri-La for securities litigation. In the previous panel, Stefan talked about the VCOM, Did I get it right? Yeah, the VCOM in the Netherlands, and that's also been held up as another example that really is an interesting possibility for pursuing transnational settlements in class action type litigation now that it's hard to do it in the U.S. And then also interesting stuff going on in Australia. All right, so I think as things are moving out of the United States, it's going elsewhere. Alrighty, so let me talk to you generally about transnational litigation in the United States courts and what that looks like. Basically, what you have, what sets up this situation is plaintiffs filing lawsuits in the United States under Rule 23, and when they file that class action, the class will include claimants from other countries, foreign claimants. And this can be pursued in our two modalities. So the class litigation can be pursued either as a litigation class with a view that the case will go to trial, or much more commonly now, the litigation will go forward as a settlement-only class. Some of these cases may not only involve claimants from other countries, but also may involve events basically that arose in another country, and also may involve defendants who are non-American foreign defendants. When you have the convergence of those three factors, basically a case involving foreign plaintiffs and a foreign defendant based on events arising in a foreign country, that's what's called an F-cubed litigation, And we have a number of examples in American courts of these F-cubed transnational litigation. The first locus where we began to see these were in the securities arena, in securities cases, in antitrust competition cases, in mass tort cases, and then the fourth category are human rights litigation. And we have a number of illustrations of this, not a number, but we have some illustrations of this prior to 2010. The case of Hilal versus the estate of Ferdinand Marcos. That was a very interesting litigation. It was a human rights litigation. It was brought against the estate of Ferdinand Marcos for basically human rights violations in the Philippines during the Marcos regime. And the plaintiffs in that case, it was brought on behalf of Filipinos and heirs and survivors of Filipinos who had been murdered, executed, disappeared, or kidnapped during the Marcos regime. That was pursued as a class action in American courts. That case actually went to trial. It's one of the very, very few cases that went to trial. It went to judgment, and there were actually claims paid out in that litigation. Anyway, the courts were open in those arenas to those types of cases. So how does the res judicata problem arise? How does the res judicata apply? Well, basically, when you have this type of class action filed in the United States, the posture of the defendant, typically, is that the defendant is going to oppose class certification. The defendant's primary goal at the outset is to try to make the case go away, and to attempt to do that is the defendant has to defeat certification by the court. One of the requirements for to certify class action, if it's a damaged class action, a B3 class action, is you have to show predominance of common questions, and you have to show that going forward as a class action is a superior means for resolving the dispute. That's what's called the superiority requirement. Now, in addition to, in either a litigated class action or if what you have is a settlement class, in either instance, what the defendant wants is global peace. What the defendant wants is global peace. They want a resolution of all claims of any claimants outstanding. Okay, they do not want, after there's some resolution of the case by judgment or settlement, to have additional claimants coming in and repeatedly suing them on the same claims. When you have a transnational suit that has in its, as part of the class definition, foreign claimants, it presents a problem. It presents a problem because the defendants are tremendously worried that either as a result of a litigated judgment or as a result of a settlement, that the home country of the foreign plaintiffs will not enforce the judgment, and will not give it res judicata effect. All right? And so if it's the case that the home court of the foreign claimants will not recognize the judgment, and plaintiffs can therefore relitigate their claims someplace else, the defendants are going to oppose class certification, and they're going to come in and object and say the court shouldn't certify it for a lack of superiority. When this issue comes up, it creates a problem for the court having to evaluate the suitability of class certification, because it involves the court in having to make some kind of assessment or judgment as to whether or not the home court of the foreign claimants will recognize the judgment and give effect to a class action judgment. And in a way, this is kind of sad to say this, but this is, I think, one of the more comical aspects of litigation in American courts. In order to prove this up to the court, both sides, on the plaintiff and defendant, have to hire experts in foreign law. And what these experts do is submit to the court competing expert reports in their interpretation of what they think the foreign law might do with regard to giving res judicata effect or enforcing the judgment. And it's always entertaining to see two competing expert reports on foreign law. And then you have a judge, by the way, who knows absolutely nothing about the law of France, Germany, Austria, wherever, okay, having to take into account competing expert reports on what the law is. So what's the more, and by the way, in most of these cases, unless the litigants can make a compelling case to the court that the class action judgment will be recognized by the foreign plaintiff's home court, in most instances, the American courts are not going to allow the foreign plaintiffs to stay in the class. And the number one reason is because of our opt-out principle and the resistance to our opt-out procedure by most other countries, right? And so once it's demonstrated to the American court that there's a high likelihood that the home country will not recognize the judgment and enforce it because they do not recognize the opt-out principle, that pretty much is going to be definitive for the court to saying we don't want the foreign plaintiffs in the class. There are other reasons, by the way, in looking to foreign law as to why an American court would reach the conclusion that an American class action judgment is not going to be given recognition. And in addition to the problem of the opt-out principle, in looking at the domestic law of some other country, they might say that there's a body of law where class actions or the particular class action procedures are against the public policy of that country. Alrighty, so again, what the defendants typically will do is they're going to oppose class certification. They're going to make an argument that the class that includes these foreign claimants lacks superiority and is not manageable, and that's the offer that they'll make to the court. What the court can do if it decides that there's a high likelihood that there will be non-recognition of the judgment, they can either just simply not certify the class, that's one option, or what they can do is signal to the plaintiff's lawyers that they're willing to certify the class, but that the foreign claimants who are included in the class definition need to be taken out of the class. In other words, they'll send the plaintiff's lawyers back to go back and redefine the class and take out the foreign claimants. Another possibility, it's a possibility, and I've never seen it work anywhere, is to order subclassing of foreign plaintiffs and to kind of segregate them off. Again, it's a theoretical possibility. So just a couple of final notes on this res judicata problem. I wanted to make mention, Professor Wasserman has written, I think, absolutely the best article talking about problems of res judicata and enforcement of judgments as it impacts in the American class action arena. And she says a lot of the scholars who write about this kind of get it wrong, as do a number of the courts, because what they do is they conflate the problem of recognition of judgments with preclusion and res judicata effects. And she makes, I think, a very fine point that it is possible under various legal regimes for a foreign country to recognize the judgment but then not give it preclusive effect. So anyway, I just wanted people to be aware of that. Also, what's that?
We're getting closer.
Okay. All right. And, so also in addressing this problem of non-recognition enforcement of judgments, the American Law Institute, in its project on aggregate litigation, actually, they have recommended and proposed that the American system shift to the opt-in principle. I'm not very optimistic about that because we have a long-standing tradition of basically not endorsing the opt-in principle. And then various academic commentators out there have various proposals for trying to deal with this. So how much time do I have?
We're already 20 minutes.
I'm already at 20 minutes. All righty. So in my abstract that you have in your materials, I talk about three cases. I talk about the Morrison case, which was the securities case in which the United States Supreme Court basically refused to extend the extraterritorial reach of American courts in dealing with transnational securities cases. In 2013, the Supreme Court handed down a very famous decision in Kiobel, which was in the human rights arena, and for the second time, the Supreme Court reaffirmed that under an Alien Torts Claims statute, there was no extraterritorial reach, and that really has impeded the ability to bring human rights class actions in the United States. I always ask my students if Hillel is still good law after Kiobel. And then the last decision was from 2014, and that was in the Daimler-Chrysler case, dealing with, again, human rights violations in Argentina that occurred during their dirty war. And in that case, the Supreme Court severely limited the personal jurisdiction of American courts, where the basis for bringing the suit in the United States was the existence of a Daimler-Chrysler subsidiary in California. And the Supreme Court said no personal jurisdiction because Daimler-Chrysler was not at home in California. So anyway, taking those three decisions collectively, the Supreme Court really has limited access to courts in transnational disputes.
Thank you very much for these interesting words, and I apologize for making it short, but to give time for the others. We will obviously have time for questions at the end of the session. Our next speaker is Professor Rhonda Wasserman that you already met in the previous panel, so I will make it short without any further introduction, please.
Good afternoon, I'm back. So I'm going to pick up sort of where Linda left off, talking about transnational class actions in U.S. courts, and picking up with the point that the principal concern of defendants being sued in transnational cases or transnational class actions in U.S. courts is the risk that they will be subject to follow-up litigation in the home court of the non-American plaintiffs. And so to reduce this risk, what American courts have been doing is to exclude the non-American plaintiffs from the class action. And this exclusion accomplishes what the defendant is seeking, which is to shield it from the risk of follow-up litigation, but it undermines important competing goals that transnational class actions are designed to serve, including compensating victims, deterring wrongdoing, and advancing the policies underlying the laws that are at issue in the lawsuit. So the thesis of my talk this afternoon is that changes in the American legal landscape enhance the risk that transnational class actions in U.S. courts will fail to compensate non-resident victims, they will fail to deter wrongdoing, and they will fail to enforce the laws underlying the plaintiff's claim. And because of those risks, I think that we need to think about alternative means of achieving these objectives. The talk will proceed in three parts. First, I'm going to identify and spend a little bit of time on the competing goals and interests that are at stake in transnational class actions. Second, I'll identify the changes in the American legal landscape that have reduced the efficacy of transnational class actions in achieving some of the goals that I'm going to talk about. And third, I will raise several alternatives that might better advance the goals of compensation, deterrence, and enforcement of the law. And as we think about the competing goals and interests that are at stake in transnational class actions, I think it's helpful to recall a very simple point, which is that these lawsuits lie at the intersection of three types of lawsuits: civil actions, class actions, and transnational class actions. And each of these types of lawsuits seeks to mediate a host of different goals and interests. So if we start with civil actions in general, they seek to advance basic public goals and competing private interests. In terms of the public goals, civil lawsuits seek to resolve disputes peacefully and efficiently with an eye to preserving scarce judicial resources, to advancing the policies underlying the laws at stake and to deter violations of those laws, and to articulate and develop that law, at least in the common law system. And in terms of private interests, civil suits seek to accommodate the plaintiff's interest in securing compensation, in enforcing private contractual and property rights, and in obtaining a judgment that will be recognized and enforced in other jurisdictions, as well as the defendant's interest in limiting its liability by advancing defenses available under the law and in securing a judgment that will be accorded wide preclusive effects and protect it from follow-up litigation. And as I've already mentioned at the outset, courts entertaining transnational class actions seem particularly concerned with the last of these interests. The subset of civil actions that are filed as class actions mediate these same public goals and private interests, but some of them are particularly salient. For example, efficiency is a particularly important goal in the class action context for reasons that we talked about earlier this morning. Likewise, advancing the policies underlying the laws at issue and deterring violations are particularly important in the class action context. And because the defendant's potential liability is so magnified in the class action context, the defendant's private interest in limiting its liability and securing a judgment that will have wide preclusive effects is also particularly pronounced. And finally, if we think about transnational class actions as transnational actions, we introduce unique concerns for the sovereignty of other nations that may be interested in regulating their own citizens and conduct that occurs even by non-citizens within their own borders, as well as the rights of the political branches of the U.S. government in establishing U.S. foreign policy, because there's concern that courts entertaining transnational class actions could somehow interfere with the prerogatives of the elected branches of government. Of all of these competing goals and interests that are at stake in transnational class actions, U.S. courts hearing these cases have focused most heavily on shielding the defendant's private interest in being shielded from the risk of follow-up litigation abroad. So at least since 1975, in the Birch versus Drexel Firestone case, U.S. courts have excluded foreign plaintiffs from class actions unless they were assured, in a process that Linda already described with the competing expert affidavits, that the plaintiff's home courts would recognize a class action judgment in the defendant's favor. And it's my position that this heavy focus on protecting the defendant from the risk of follow-up litigation discounts the competing values and interests that are at stake in transnational class actions, such as compensating victims regardless of nationality, deterring wrongful conduct both here and abroad, and enforcing the policies of the laws that are at issue in the litigation. And this risk that transnational class actions will fail to serve these countervailing goals and values and interests has been enhanced in recent years by a number of Supreme Court decisions in a number of different areas, one of which Linda mentioned, Supreme Court cases that limit the geographical reach of U.S. law. Another set of cases I mentioned very briefly earlier this morning on contractual bans of collective action, and Supreme Court decisions that make it harder to certify a class action. So I'm going to talk a little bit more about each of those changes in the landscape that reduce the efficacy of the transnational class action, starting with the presumption against extraterritoriality. Until 2010, lower federal courts interpreted Section 10B of the Securities Exchange Act, which regulates securities fraud, as applying extraterritorially outside the territory of the United States in two circumstances. First, under the effects test, if conduct outside the United States caused substantial harm within the United States or harm to U.S. citizens, or second, under the conduct test, if substantial acts in furtherance of the fraud were committed within the United States, even if the actual sale of the securities occurred outside the United States. And this understanding of the extraterritorial reach of Section 10B was dramatically altered by the Supreme Court in the Morrison case decided in 2010. And in that case, the Supreme Court revitalized the presumption against extraterritoriality, stating, where a statute gives no clear indication of an extraterritorial application, it has none. In that case, some fraudulent conduct had occurred within the United States, and the Supreme Court nevertheless held that that fact didn't necessarily make the federal law applicable or the presumption against extraterritoriality irrelevant. In Justice Scalia's now famous phrase, the presumption against extraterritoriality would be a craven watchdog if it retreated to its kennel whenever some domestic activity was involved in the case. So U.S. law applies under Morrison only if the domestic nexus is the focus of the statute. And in Morrison, the court concluded that the focus of the Securities Exchange Act is purchases and sales on domestic stock exchanges or domestic transactions in other securities. So in that one case, in one fell swoop, the court replaced the long-standing conducts and effects tests with a robust and revitalized presumption against extraterritoriality that dramatically limits the reach of U.S. law. And it was only 3 years after Morrison that the Supreme Court decided the Kiobel case, and the court there had originally granted cert to decide the question whether corporations are subject to suit in the United States under the Alien Tort Statute for international law violations. So the focus was on corporations specifically, but it later requested briefing on a much broader question, whether the Alien Tort Statute allows U.S. courts to adjudicate claims for violations of the law of nations occurring outside the territory of the United States. The statute, the Alien Tort Statute, grants courts jurisdiction of any civil action by an alien for a tort only committed in violation of the law of nations or a treaty of the United States. And prior to Kiobel, the lower courts had invoked the Alien Tort Statute to hear claims for international law violations arising from conduct that occurred outside the territory of the United States and inside the territory of a foreign sovereign. But in Kiobel, which was a case that involved violence by the Nigerian military in Nigeria against Nigerians, the U.S. Supreme Court concluded that the presumption against extraterritoriality applies to claims under the Alien Tort Statute. So if you read Morrison and Kiobel together, they have reinvigorated the presumption against extraterritoriality and have limited the efficacy of litigation in U.S. courts to compensate non-American plaintiffs and to deter violations of U.S. law that may occur outside the territory of the United States. And as we're about to see, a number of other restrictive decisions regarding the class action vehicle exacerbate these problems. First, as I mentioned earlier this morning, and I'll go through this pretty quickly now, a pair of Supreme Court decisions regarding class action waivers have made it easier for corporate defendants to shield themselves from class actions altogether, potentially immunizing themselves from liability for wrongdoing on a very grand scale. The first of these cases, and this is the one that I didn't talk about this morning, is AT&T versus Concepcion, which was decided in 2011. And in that case, the plaintiffs challenged a term in their cell phone service contract, which required that all disputes with AT&T be arbitrated rather than litigated, and required that any claims be brought individually rather than as part of a class action. Now, under California law, this particular class action waiver would have been unenforceable because the courts there would have deemed it unconscionable both as a procedural and substantive matter. But the Supreme Court in the Concepcion case concluded that the FAA, or the Federal Arbitration Act, preempted California law. So even though the state law would have invalidated the class action waiver, the Supreme Court held that the waiver was enforceable. It reasoned that class-wide arbitration would have sacrificed the informality of the arbitration process, it would have increased its cost, and it would have increased the risk that the defendant would have felt financial pressure to settle even meritless or questionable claims. So because in the court's view, class-wide arbitration would have interfered with the fundamental attributes of arbitration, it viewed the California law as inconsistent with and therefore preempted by or displaced by the Federal Arbitration Act. And it was only 2 years after that that the Supreme Court decided the case I mentioned this morning against American Express, where it made clear that class action waivers are enforceable even if they interfere with the vindication of rights under federal law. So if you read these two decisions together, Concepcion and the Amex case, they increase the risk that corporations will be able to immunize themselves from liability by defeating the opportunity for plaintiffs to join together collectively. And so to the extent that they're able to shield themselves from liability, the goals that I talked about earlier in terms of deterrence, compensation, and enforcement of the law all will be frustrated. And then the last sort of category of cases that I want to talk about are interpretations of Rule 23 of the federal rules that also restrict the opportunity for private enforcement of federal law through class actions. So we talked a little bit this morning about the Walmart case, but I want to emphasize for you that this decision came down just 2 months after the Supreme Court decided AT&T versus Concepcion. And the Supreme Court in the Walmart case concluded that a nationwide class could not be certified there, and this was an enormous employment discrimination lawsuit, because the plaintiffs had failed to establish commonality. That is the requirement that there be questions of law or fact common to the class. And the language of Rule 23 speaks in terms of common questions, but the majority read it to require common answers that would resolve a central issue in the case. And by focusing upon the dissimilarities within the proposed class that had the potential to impede the generation of common answers, the court appeared to conflate Rule 23A's threshold commonality requirement with the Rule 23B3 requirement, the more rigorous requirement, that the common questions predominate over the individual questions. Walmart also required that the plaintiffs introduce substantial proof of the existence of a general policy of discrimination, and they were very skeptical of the use of statistics to help establish both the claim on the merits and the proof of the class's damages. So if you take together the presumption against extraterritoriality, the proliferation of class action waivers, and the heightened certification requirements that under Rule 23 that the Walmart court imposed, it makes it much less likely that transnational class actions in U.S. courts will be a reliable vehicle for compensating foreign plaintiffs or deterring violations of federal law that occur overseas. And so the question that I'll end with is, what alternative means are there to achieve these goals? And there are a couple of possibilities that could take place in the United States. At least in theory, Congress could take action. They could amend the Federal Arbitration Act to ban class action waivers. They could explicitly amend certain statutes to evince explicitly an intent for the law to apply extraterritorially in certain circumstances. I'm not confident of any of those changes given the gridlock in Congress and an unlikely interest in doing those things. In theory, Rule 23 could be amended by the advisory committee, but there's no indication that they have an interest in doing that, at least with respect to the heightened certification requirements. And even if they did propose those changes, they would have to be approved by the Supreme Court. And so the third possibility that I would just throw out in terms of domestic reform is to shift from a scheme of private enforcement to one of public enforcement. This is a suggestion made by Professor Miriam Gillies and Gary Friedman that state attorneys general could step up and bring litigation on behalf of their citizens. And I think that that change in American legal culture is also quite unlikely and would do nothing to resolve the concerns with transnational litigation because the authority of the state attorney generals would be limited to representing the citizens of their own states. So if reforms in the U.S. are not likely to achieve the goals that I'm concerned with, we need to shift our attention to possible litigation strategies and other regulation outside the United States. Other reforms elsewhere or other practices elsewhere that could achieve the objectives of compensation deterrence without the potential infringement upon the sovereignty of these other nations. And so we've talked a fair bit about the options already today, and I don't want to, I'm certainly far from the person to do that. So the last thing that I'll do is just to suggest, to reinforce maybe a couple of points made by the true experts in terms of collective redress in other parts of the world. One is the discomfort with the U.S. opt-out regime and a more common requirement abroad that class members opt in. And I think we all understand the benefits of structuring litigation in that way, but the downside is that they are far less inclusive, and so you don't benefit as many class members as you do when you have an opt-out system. Second, given the concern or skepticism regarding the contingent fee that we have in the U.S., there are questions about how class actions and collective redress will be financed outside the United States. And I know that in the UK and in Australia there are other means of private litigation funding, but I think that's an issue that needs to be grappled with. And third, there's been a lot talked about in terms of the loser pay system of attorneys' fees in other parts of the world, but that does run the risk of inhibiting the prosecution of class actions by those that may be bringing cutting-edge litigation, afraid that their cutting-edge claims won't be accepted and that they're going to have to cough up an awful lot of money to compensate the other side. So I hate to end on such a discouraging note, but it's not, I'm not so optimistic that collective actions are going to achieve the goals of compensation, deterrence, and enforcement of the law. And I, for one, am disappointed in that. So let me end there. Thank you.
Thank you, Professor Wasserman, for this already second interesting lecture. Is there going to be a third one?
No, I think I'm done.
The next speaker would be Professor Stadler, which you've already met, so I'll also be short in her introduction. She will speak about transnational class actions from a European perspective and the global impact of U.S. class actions on claims for collective redress in Europe.
Yes, thank you very much. I'm also back quickly. According to the original plan of the organizers, Arthur Miller was expected to give a presentation this morning with the title Myth and Reality of the American Class Action. And I like this title very much, and I like to use it for my presentation as well and add from the European perspective. Well, the European perspective is a challenge because, as you can imagine, there is no uniform European approach. Europe does not speak with one voice. And I have to apologize that maybe my presentation is influenced very much by the German attitude towards class actions. Well, there is much misunderstanding in Europe about US class actions, and we have also seen numerous efforts in Europe from the business sector to discredit class actions. Conferences on collective redress in recent years were full of anecdotic evidence presented by European companies describing unmeritorious claims resulting in expensive and blackmailing settlements, class actions in the US. All this did not fail to have a strong influence on the European debate on collective redress and on its outcome. The fact that the European Commission could only issue a recommendation and not a legally binding instrument, only soft law, was the strong resistance, particularly in Germany and in France, the whole business sector, and they gained the support of the government. In France, the attitude has changed. They have a new government, and since then it was much more easier to implement new instruments of collective redress. In Germany, there was no change, and we still have this very strict attitude. And this resistance also influenced the recommendation itself. Like a mantra, we heard again and again about the potential misuse of class actions and blackmailing effects. And also some well-known US scholars like Deborah Hensler, for example, keep telling us that there is no such potential for misuse. I'm personally convinced that US-style class actions can be misused and that they are misused in some cases, at least. It is, however, the famous so-called toxic cocktail, Chris has mentioned that this morning, which makes US class actions a dangerous instrument. And European law does not offer the ingredients for this toxic cocktail. However, some argue that it is a slippery slope, and once we make the decision to have class actions, other decisions will follow. The next decision will probably be, well, the most effective way to do is opt-out class actions, and then we've heard that this morning, we need incentives for lawyers, so we need contingency fees, and finally, we end up with all the ingredients for the toxic cocktail. So nevertheless, this was one of the reasons why I think the majority of scholars in Europe argued that we need a European style of instrument, a European group or class action, and we should not adopt all the downsides of the US class action, but this is difficult to decide. Well, I'd like to mention 3 points in my presentation now. One is the already mentioned public versus private enforcement issue, and then the Morrison case, and finally I'll come to the question whether US class action settlements or decisions will be recognized in Europe. Public versus private enforcement. We've heard about that a lot this morning. And one of the main reasons, I think, why the US class action system does not easily fit into the European legal framework is this well-known antagonism between public and private enforcement. Public enforcement historically prevailed in most European states and still prevails today, particularly in the field of consumer law, securities law, or antitrust law. And whether there is a need for private enforcement to substitute public enforcement or to work as a supplement to public enforcement, there is not debated intensively in all member states. Maybe we should recommend to policymakers all the new book of Chris Hodges on public enforcement, but I'm afraid 800 pages are a little bit too much for policymakers, so maybe you can publish a short version. Well, private enforcement, the way it is practiced in the US, meets considerable discomfort in Europe for well-known reasons. One reason we've discussed this morning, the US system seems to be inevitably founded on tremendous financial incentives, greed for lawyers, And the US have undeniable difficulties to cope with lawyer-driven lawsuits. The same is now obviously the case in Israel. The US concept of applying the rules of market economy on the enforcement of private law and to accept lawyers as key actors in this play is contrary to the European approach. Therefore, the boogaboo of US class action strongly influenced the collective redress debate in Europe. The EU Commission's recommendation tries to do the impossible. They wanted to provide better access to justice, but at the same time they suggested a lot of safeguards against potential misuse, and this is probably the reason why none of the European countries really followed that recommendation, because it's simply impossible if you want to have an effective instrument. Well, I will shortly mention the Morrison and the Keobel case and its implications for Europe. We all know that despite the legal controversy and resistance against US class actions, lawyers and claimants are sometimes very happy to be a class member in a US class action. And since the Supreme Court now has restricted access for foreign claimants in at least the F-cubed cases to US courts, shareholders and other claimants in Europe have to look for other attractive options. And it has been mentioned already that the Dutch Settlement Act, the WACOM, which offers a special procedure for giving binding effect to settlements, is one of these attractive alternatives. The WACOM was originally not meant to be an instrument for transnational cases. It was meant to be a purely domestic instrument. Stefan has explained that. But now suddenly it became extremely attractive for the international cases, particularly for the big security cases. And recent reform in England and Wales copied the successful model and implemented similar instruments. In this respect, the US Supreme Court was very helpful, and it moved forward reform in collective redress in Europe. However, in the international cases, the WACOM proceedings raise some difficult questions, and they are quite similar to the questions raised by US class actions. Stefan has mentioned that already. One is the international jurisdiction of the Amsterdam Court in the WACOM proceedings. From a legal perspective, I think it is very difficult, if not impossible, to confirm international jurisdiction of the Amsterdam Court in many of the cases which have been settled in this way now. But as you already said, it is a political issue, and there was a need for such an instrument to settle these cases in favor of European shareholders who did not have any chance in the United States or elsewhere. So it was a political decision of the Amsterdam Court, and it worked so far. Another issue is the recognition and enforcement of these WACOM settlements. Enforcement is not so important in practice. It's recognition, and it is the preclusive effect which is very important, because, as you already explained, defendants will enter into a settlement only if they can buy global peace. So it's very important for them that no individual actions are at the horizon, and that they can rely on a legally binding effect for all the claimants, or at least for a vast majority of claimants. For the WACOM, exactly this question is open. We do not know whether the WACOM settlements will really be recognized and enforced in other member states. There is no decision of the European Court of Justice, and I think the parties had a great interest to prevent that the European Court of Justice decided this question until now. Well, I think with the upcoming model in the UK, one day we will have to decide at least the decision of jurisdiction, because now there is a competition between London and the Netherlands, and the question will come up for the European Court of Justice to be decided. Well, let me finally address an evergreen with respect to US class actions and the European legal system, the question whether US class action settlements or decisions have a chance of being recognized and enforced in Europe. There are very few court decisions in this respect. There is none of the European Court of Justice. There is none of the Federal High Court in my country, and as far as I know, none of other high courts in other European member states. And again, the preclusive effect is, in practice, the most critical issue. Surprisingly, the question has been raised more often in the US than in Europe, and as you described, US district courts had to tackle the issue during the certification process, when they had to decide whether European claimants should be part of the class or not. And indeed, in the Vivendi, Ahold, and Royal Dutch Shell cases, there were a number of expert opinions presented by famous European scholars, and there was no uniform answer to the question whether US class actions would be recognized in Europe. Even experts giving affidavits for the same European country did not give the same answer. That is entertaining, as you said. It is bizarre to some extent, but they all had very good arguments for their position. And in some cases, particularly claimants from Austria and Germany were excluded from the class, where, as far as I see, claimants from France and the Netherlands and the UK, they were accepted because there was a better chance that the US decisions would be recognized. So until today, there is no uniform answer. And in the absence of international treaties, the question whether US decisions will be recognized and giving effect in European countries depends on the national rules of the European countries. These national rules have much in common. If you look at them, the basic requirements are more or less the same. One is that there is no violation of exclusive jurisdiction in the state of recognition. There must be mutual recognition. The principle of reciprocity applies. And there's finally the requirement that there is no violation of public policy. And public policy can be procedural public policy or substantive law. So what are the critical issues in terms of this public policy? It is indeed particularly the opt-out mechanism which meets a lot of concern in Europe. Public policy can be raised as an objection if the decision violates fundamental rules in the country of recognition or violates even constitutional rights. It certainly cannot be invoked now in European countries which have implemented opt-out proceedings themselves. So I think in the Netherlands, in Belgium, in the UK, probably US opt-out class actions will have no problems to be recognized. The EU Commission's recommendation is not a very good guideline because it says, well, we prefer opt-in proceedings, but there is immediately in the next paragraph, there is an exception which says, well, in extraordinary situations, if access to justice makes it necessary and if there are good reasons, then opt-out is also possible. So we can only conclude from the recommendation that under exceptional circumstances, the opt-out proceedings are acceptable in Europe. Let me give you just a short overview of the arguments. Why is the opt-out mechanism a matter of concern? I mentioned earlier in my last presentation that there's a strong resistance in Germany against opt-out instruments. And why can opt-out mechanisms violate constitutional rights? Well, the first is the right to be heard for the absent class members. The binding effect of the class action settlement or court decision, whatever, is problematic if the absent claimants did not have a fair chance of opting out of the proceedings. And this depends on the means you give notice to the absent claimants. And another aspect is the right of claimants to decide for themselves whether they want to sue the perpetrator or not. This is a constitutional right, for example, under German law. It is a parallel to the freedom of contract in procedural terms, so everybody should decide for themselves whether they want to go to court or not. And the well-known argument from the US that the majority of claimants do not want to opt out. They are happy that they are part of the class, that they do not have to lift a finger and that they will take benefit from the class action, is not well accepted in Europe. One reason might be that in Europe, at least for medium-sized damages, claimants have a realistic option to enforce their claims individually. In some countries, not in the UK, but in other countries, legal costs are very low. We have legal aid. And therefore, even consumers have a good and realistic chance to enforce their claims individually, and that has to be respected. The opt-out mechanism will certainly not raise objections if there was personal notice given to all the claimants. Yeah. But you can't do that in all the cases. The really tricky class actions are, of course, those where you have a large group of unidentified claimants, which is the case in most security cases, product liability cases, and even antitrust cases. So what are the arguments against recognition in this case? The only way to give notice to the claimants is public notice. You can publish the notification in the internet, in newspapers, and things like that. But you have always taken into consideration that you will not reach all the claimants. Some of the claimants will not read the newspapers. They will not go on the internet. And there is even an argument that you cannot expect consumers or claimants to go on the internet and search whether there are any class actions pending, including their claims. And it's interesting that in the UK, the new class action in antitrust law is based on an opt-out mechanism, but only for those claimants residing in the UK. Claimants residing out of the UK, they must opt in to become part of the class, and the reason is that it's much more difficult to give them adequate notice of the proceedings. Another argument is that, well, it is really important to give them notice because aggregate litigation always involves restrictions of the absent claimant's right in terms of procedural rights, but also in terms of substantive rights. Most of the proceedings will end up in a settlement, and this always includes a compromise. So we have probably to respect the individual's choice between a class action and an individual lawsuit. Well, nevertheless, I have the feeling that the attitude in Europe has changed a little bit. Years ago, there was more or less a uniform rejection of the opt-out mechanism, but since we have some member states now who have already implemented opt-out proceedings, the attitude is changing. And more or less, the arguments in favor of opt-out are accepted. There is a public interest behind these instruments. It's more inclusive. We can help more consumers because the opt-out rate is normally very low. The proceedings are more efficient. And it is, at least in the United States, it is an important instrument of private enforcement. And if you do not have much public enforcement, you need this instrument. So, in conclusion, I'm afraid there is still no clear answer in Europe whether US class actions will be recognized. In any case, European courts will look very closely to the way notice has been given to the class members. And I dare say that in a number of member states now, opt-out class actions will be recognized if it is a large group of unidentified claimants and if they have only small individual damages and there is no realistic option for them to enforce their claims individually in the United States. In Germany, there is still a strong resistance, but we have mentioned the VW scandal very often today, and that might change the situation because 2 weeks ago, when I checked the internet, I think 230 class actions were pending in the United States. And maybe some German consumers get the feeling that they were better protected under US class action than under the German system. So that may change the attitude. Thank you very much.
Thank you very much. I will now, first of all, I will introduce myself because no one else will do it for me. I'm the head of litigation at Herzog, Fox & Niemann, and my practice is also dealing with defending in class action claims, including foreign entities. I would speak mainly on the Israeli angle, but I would like to make 3 notes beforehand. As far as I would make my reservation in addition, most of the talk would be with regard to the Verifone case. My firm, it wasn't myself, acted for Verifone in that case, so I'm not speaking on behalf of Verifone. Those are just my opinions and my reading of that decision. 2 comments. The first one with regard to the Morrison decision. I think it is important to mention that, and that was actually emphasized by the Supreme Court, that Morrison was not a decision on jurisdiction. Morrison the Supreme Court in the Morrison case specifically criticized the Second Circuit for categorizing this as a jurisdiction claim, but rather Morrison was an interpretation of the substantive law, in that case Rule 10b of the securities law, and not an issue of jurisdiction. And in fact, you can see that even today, in 2014, there was the quite known decision in BP regarding the oil split in the Gulf of Mexico. And in that case, the district court decided to adjudicate a case of a company that its shares were traded in the London Stock Exchange. The claim was based on English law, and yet the district court denied the motion to dismiss on ground of form of non-convenience. So we see that even after Morrison, although the gate was narrowed, there are still even security class actions of foreigners in the U.S. The second comment, which I would like to make, is with regard to, you mentioned the fact that it's odd to find conflicting opinions with regard to the European law, whether it would be enforceable or recognizable, and whether there would be a preclusive effect. In fact, when I read it, it was even more weird because I found contradicting decisions. While in the Vivendi case, the court found that the French courts would enforce the judgment in a U.S. class actions. In the Alstom case, the court decided that the French court would not enforce such a judgment. Vivendi was in 2007 and Alstom was in 2008. So since this is foreign law and since it is proved to the court by way of expert opinions, that the result is that sometimes courts make contradicting decisions with regard to the foreign law that was presented to them. The main I will skip that. The main part of the discussion would be the Verifone case, and in fact, we. Okay. Thank you. The question, which was an open question, which is still an open question in Europe and in Germany, whether U.S. judgments in the framework of class actions would be enforceable in Europe, was also an open or questionable issue in Israel until recently, until April 2015, when the Supreme Court, actually retired Justice Grunis, ruled on the Verifone case and made it clear, and I'll go to the bottom line, that a U.S. judgment or foreign judgments in class actions would be recognizable and would have a preclusive effect in Israel, subject to certain conditions that I will discuss in a minute. Sorry. Okay. Just for the facts of the case, Verifone was a Delaware company. It was a company with dual listing both in the New York Stock Exchange and the Tel Aviv Stock Exchange. There was an error in the financial reports of Verifone, and as a result, and after Verifone announced that error, several class actions were filed in the US. They were eventually consolidated to the District Court of Northern of California. Shortly thereafter, a petition to certify a class actions against Verifone was also filed in Israel by Mr. Stern. This was filed only on behalf of the holders of Verifone shares in the Tel Aviv Stock Exchange. After Verifone filed a motion to dismiss the petition for certification in limine, or alternatively to stay the proceedings in Israel until a decision is made in the pending case in California. After different proceedings in Israel, which were quite, we have also counsel for the other side in the room, so there were quite exhaustive proceedings with regard to the law, to the applicable law, and to staying the proceedings, but eventually the plaintiff in Israel agreed that this petition will be stayed in light of the proceedings that were pending in the US, while reserving the right to reinstate the proceedings at a later stage. Ultimately, a settlement was reached in the US proceedings. The settlement applied to everyone who held Verifone shares either on the New York Stock Exchange or the Tel Aviv Stock Exchange, meaning including the putative class in the petition for certification in Israel. The Israeli petitioner, Mr. Stern, filed an objection to the approval of the settlement with the court in California. The objection was filed on his personal behalf and also on behalf of the class that he purported, the Israeli class that he requested to represent. And he attended a hearing as well as with an Israeli attorney. They also hired a US counsel to assist them in that objection with regard to the settlement. And subsequently, after the California court requested additional publications, we won't get into the details, but the bottom line is that the California court approved the settlement and found it to be fair and proper and rejected the objection. The California court did specifically say that the approval of the settlement agreement is not intended to dictate to the Israeli court the enforceability of the releases contained in the settlement agreement. After the settlement was approved, Verifone argued before the Israeli court. It was actually the Supreme Court because the case was pending there, that the settlement that was approved in the US court is res judicata and has a preclusive effect concerning the petition for certification in Israel, and therefore the petition before the Israeli court should be dismissed in limine. Verifone filed an expert opinion concerning the foreign law, according to which the approval of the settlement in the US constituted res judicata towards the members, all the members of the class who did not opt out. Okay? Mr. Stern, on the other hand, objected to that and raised various arguments. Some of the arguments related to the due process and whether or not the Israeli members of the class receive adequate notice of the settlement and the petition. That was one set of arguments. The other set of arguments related to the fact that, according to Mr. Stern claims, the Israeli law accorded the Israeli class a better protection than the US law, unlike in the US where there was a need to prove fraud or bad faith. No such requirement existed in the, under Israeli law, and therefore the argument was that the members of the Israeli class should have been received a higher compensation than the rest of the class. The Israeli Supreme Court analyzed the matter and ruled as follows. First of all, there was a general discussion regarding the enforcement of foreign judgments in Israel for the purpose of res judicata. The way to do that is by an indirect recognition by virtue of Section 11b of the Enforcement of Foreign Judgments Law of 1958, which provides that in the course of the hearing of a matter which is within its jurisdiction and for the purpose of that matter, a court or tribunal in Israel is entitled to recognize a foreign judgment should it find that doing so is required both by law and justice. As you could realize, this is a very flexible provision which gives the court quite a lot of room. And in fact, most of the conditions for the recognitions were set by the courts in a way of common law, since they are not part of the law itself. Now, according to the court rulings, the first issue that the court must satisfy is that the foreign court, which rendered the judgment, had jurisdiction to do so. That's a very clear and trivial condition. It should be noted that when there is no dispute with regard to the jurisdiction of the foreign court, and actually the plaintiff or the defendants argue to the merits, they would be stopped from arguing later on that the foreign court had no jurisdiction. An additional condition that should be examined is if the parties' rights for due process were protected. This goes to rules of natural justice, and mainly whether there was a fair opportunity to raise questions before the foreign court. In regular cases, this is mainly the interest of the defendant against which the judgment is being enforced or being recognized. Other considerations are public policy. Although these are very rare cases, the Israeli court is not supposed to look into the merits of the decision and should prevent recognition only in cases where such a decision contradicts the Israeli public policy. For such indirect recognition, according to Section 11b, there is no need for any mutual convention, and even reciprocity is not necessarily required. And finally, even if the judgment should be recognized, there is a second and separate question, and that is what is the preclusive effect of that recognition. Our Supreme Court did not make the mistake, Professor Wasserman, that you indicated in your article, that courts tend to confuse between the two, and when to check this second stage. It is not clear from the ruling, but my understanding of the ruling is that the Supreme Court in Israel checks the preclusive effect both under the foreign law and according to the Israeli law as cumulative conditions. As far as the foreign law is concerned, in cases that foreign law was not presented before the Israeli court, the court is willing to satisfy itself with the equality of laws presumption that assumes that the foreign law is identical to the Israeli law. Now, moving to the issue of judgments in the framework of class actions. The court noted that the considerations, the same Article 11b can serve as a tool for the recognition of judgments which were rendered, foreign judgments which were rendered in the framework of class actions. Nevertheless, the Supreme Court did recognize the fact that the considerations are different. I think that the main consideration is that while in recognizing or enforcing a foreign judgment, a regular foreign judgment, the main issue is whether the defendant had adequate protection. Here the question is different, and the question is whether the members of the class, the absent members of the class that were represented without actively participating in light of the opt-out mechanism in the US, whether they had sufficient protection in the framework of the foreign proceedings. And therefore, the conditions that the court set were different. In the decision, the Supreme Court did look at the IBA guidelines from 2008 as an interpretive tool. He also did the same with regard to decisions in the US and in Canada. The first difference, I would say, between the two is with regard to jurisdiction. When it comes to a foreign judgment on class actions, it is not sufficient to demonstrate that the foreign court has jurisdiction. There is a need to show that the foreign court had real connection to the dispute which is the subject of the class action. Okay? And the reason is to avoid issues or situations of foreign shopping, that the plaintiff and or the defendant would choose a convenient venue which has no real nexus to the dispute at hand and create res judicata for other jurisdictions as well. So I think that this is the first difference that should be made. For examples, for real connection, if significant part of the group is situated in the country where the judgment was rendered, that is a relevant connection. Another connection that was mentioned by the Supreme Court is that if the reasonable expectations of the parties was to litigate in that jurisdiction, that would also be considered as a relevant factor. For example, jurisdiction clause could, to a certain extent, attest to the reasonable expectations of the parties in that respect. The second difference is with regard to the element of due process. As I mentioned before, this was also an element with regard to regular foreign judgments, but when it comes to class actions, this is a much more crucial element. And in fact, the Supreme Court mentioned three subcategories of this requirement. The first one was proper notice of the existence of the class action and an opportunity to participate in that process. That was the first element. The court said that it seems that there is no need to set a personal notice. It's clear that it's not realistic. And the way, this is my understanding of the reading, at least that's the situation in Canada. There is no need for, the guidelines do say that when it's practical, it would be preferable to send personal notice. It really depends on the circumstances. It was not decided in a decisive manner what's the proper way. The second element is an opportunity to opt out, which is obviously a trivial matter. And the third element is proper representation, which doesn't mean necessarily the quality of the representation, but rather that there is no conflict of interest between the class action petitioner and the class, or between two parts of the class, or between the lawyer of the petitioner and the class. Of course, the clear example for conflict of interest is that if one group or one subclass receives more than the other subclass. But at the same time, it was argued that if the rules, the substantial rules, are different, then maybe providing a flat payment would be the one that discriminates between the two subclasses. The court made it clear that the Israeli court should not examine the terms of the settlement and should not approve a settlement only if it is patently inadequate, very similar to the IBA 2008 rules. There is the issue of allowing indirect attack, meaning what is the possibility of the members of the class to claim before the Israeli court that the process before the foreign court was not a due process. And the question is raised in situation where some of the members of the class, as in the Verifone case, actually attended the hearing before the foreign court, the California court, made their arguments, and their arguments were denied. The court mentions three approaches without making a clear-cut decision which of them should be adopted in general. There is the narrow approach, which says that it's enough that there was an opportunity to raise the arguments, even if they were not actually raised or decided, in order to prevent a second round before the Israeli court. The second, the more broader approach is to say that only the plaintiff, the Israeli plaintiff itself, or those who objected their settlement in the US, in the foreign court, only they would be barred from making arguments with regard to those issues that were specifically decided by the foreign court. And there is the third approach, which says that the bar would only apply to issues that were raised and decided by the foreign court with regard to due process, but it would bind not only those who made the arguments, but also the entire class. What the court did say, that as opposed to the regular adversarial system in Israel, whereby the Israeli court would not raise arguments against the enforcement of foreign judgments if those were not raised by the defendant himself or herself, when it comes to recognition of foreign judgments in the framework of class actions, the court would be more active and there would be greater supervision in order to protect the rights of the absent members of the class who did not participate in the foreign proceedings. And finally, when it comes to the preclusive effect of the foreign judgment, the court again makes it clear that that should be decided both, or that's how it looks, both under the foreign law and under the Israeli law. Now, as for the specific decision in Verifone, the result was clear. The motion, the petition for certification was denied, and actually it was dismissed. The court found that the California court, the Israeli court, found that the California court had both jurisdiction, which was not contested, and also had real connection due to the fact that this was a U.S. Company. It was with dual listing, and also the court decided that those arguments regarding due process that were alleged by the plaintiffs themselves could not be raised again before the Israeli court, meaning that the Supreme Court did not check those arguments to their merits due to the fact that they were already raised and decided by the California court. The Supreme Court did leave it open whether the other members of the class, actually says that the other members of the class are not barred from arguing before the Israeli court that there was no proper due process. Okay? Nevertheless, the Israeli court made it clear that even with regard to those members, the California decision does have an effect that the court would need to consider. If I may say, the court did not refer, the Israeli court did not refer to the counsel acting for the petitioner, but I think that in light of the unique status of a counsel in Israel under the class action law, and there are decisions, at least of the district court, which do not enable, for example, the petitioner to replace counsel in class action proceedings, because it's not like regular claim where the petitioner is the sole owner, so to say, of the proceedings. I think that while it was not referred to in the, I see that you're taking notes. While it was not referred to in the case, I think that the same estoppel should apply at least to the very same lawyer that acted for the petitioner in that case. This is not theoretical. A month and a half, or even less than a month and a half after the decision in Stern versus Verifone, a new petition for certification was filed by another member of the class, Mr. Moshe Hyatt. This is still pending before the court. I will not get into it. I think I said enough on that. One last remark, going now to the Vivendi, Alstom cases. I think that if the case if a petition for certifications come now before a U.S. court, in the name of Israeli members of the class, it is safe and it is clear to say that an Israeli court would enforce the U.S. judgment, provided that the U.S. court would have jurisdiction and provided that there is a real connection to the U.S. court. Of course, there is another condition, which is the due process, but I think that the U.S. court must assume that it would apply a due process. This is something that you can only check in retrospect. I don't think that the U.S. court would say in advance, well, there would be no due process for the foreign litigants. That is all on this issue. Thank you very much. I lost track on time because my iPhone is in the room. If there are any additional questions, if we still have time. You will have to skip the questions. Okay. Thank you.
Thank you very much. We go